Hayes.
That's correct, Your Honor.
All right.
State's Exhibit 594 is the letter from September 26th of 2011. State's Exhibit 595 is from January 17th of 2012, and State's Exhibit 596 is from February 7th of 2012. Additionally, the recording that I spoke of, we intend to publish to the jury. I don't have it on a CD yet, but I have it on my computer. I intend on entering that as State's Exhibit 597, which would be represented by this piece of paper if the court would allow it, and at a later time I'll put that sticker on the CD that has the copy of the recording on it.
Okay. Have you played that, or have the defense counsel heard it?
We've heard it, and we're satisfied with that arrangement with them using the paper as a substitute for the CD for the purposes of admission today.
Do you want to be heard? I mean, your whole argument to me up to this point was that they can't do this without calling Patsy Hayes. They having announced they're going to do it, do you want to be heard on whether or not they should be permitted to call Patsy Hayes? I'm just asking if you want to be heard.
No.
Okay, fine, thank you. I just don't assume anything anymore unless you tell me.
I understand.
Okay. All right. Ask the jury to come in, please.
I don't know.
We're in session. Thank you for your patience. It's my understanding that the state intends to call one additional witness, and under the protocol of the court, I was required to preview that information. I have done that and have ruled on technical aspects of that information, and we're prepared to go forward. You may call your witness.
State calls Patsy Hayes.
Ma'am, come up, please, if you would. There's a Bible right there. If you just stop right there at the Bible, if you put your leg, do you want to be affirmed or sworn? Affirmed. Just raise your right hand then, please.
You solemnly affirm that the testimony you give this court will be the truth, the whole truth, nothing but the truth, and is that your solemn affirmation?
Thank you. Come around, please, and just have a seat. If you would kind of scoot up close to the microphone and talk right into the microphone, please. Thank you. You may proceed.
Ms. Hayes, could you state your name for the record?
Patsy Ann Hayes.
And are you the mother of Grant Hayes?
Yes, I am.
And that is Grant Ruffin Hayes III?
Yes, I am.
And currently, do you have custody of the two little boys, Grant IV and Gentle Hayes?
Yes, I do.
And Lily Hayes as well?
Yes, I do.
Okay. Back in July of 2011, were you questioned by police officers and detectives as part of this case?
Yes.
Okay. And additionally, today, did you contact the DA's office because of some materials that you had?
Yes, sir. My husband did.
Okay. Your Honor, can I approach the witness?
You may.
Ms. Hayes, I hand you, it's been marked for identification purposes, the State's Exhibit 594, 595, and 596. Are these three letters that you had received prior to today's date?
Yes, sir.
And who are those letters from?
Those letters are from Amanda Hayes.
Okay. And do they indicate on the envelopes that State's Exhibit 594 appears to be a letter from September 26th of 2011?
Yes, sir.
And State's Exhibit 595, does that appear to be January 17th of 2012?
Yes, sir.
And on State's Exhibit 596, does that appear to be February 7th of 2012?
Yes, sir.
And could you explain the why you, we'll strike that. Did you contact our office today to let us know about the existence of these letters?
Yes, sir.
Okay. Additionally, did you bring with you here today a recording from your cell phone?
Yes, sir.
And was that recording a voicemail left on your cell phone from July 13th of 2011?
Yes, sir.
And that recording on your cell phone, that was from who?
That was from my son, Grant Ruffin Hayes III.
Okay. And that recording, do you recall, was it from 3:37 p.m. on July 13th of 2011?
Yes, sir. About 3:30. Yes, sir.
Okay. And you're able to pull that up by listening to more options on the voicemail?
Yes, sir. The detective.
Okay.
He was able to do it. Yeah.
And as part of that, did you save that message all the way from 2 years ago till today?
Yes, sir.
And have you been able to listen to it here today?
Yes, sir.
And does it appear to be Grant's voice on your voicemail?
Yes, sir. It is Grant's voice on the voicemail.
Your Honor, I move to enter that recording, which I've labeled as State's Exhibit 597, the recording from July 13th, and I'd ask to publish it at this time.
Let it be received. You may publish.
Volume on.
Received. Next message. Hey, Mom, it's Brad. Me and Amanda and Lily are going to move in with you guys. If you could, I don't have the money for storage facility. If you or Dad could go get us one and we could start moving this weekend. I know your house might not be ready, but we don't have to be out of here right now. So we can move over the next week. I would like to go ahead and start putting some stuff in storage. But once again, like I said, I don't have the money for a storage building right now. If you could fund that to me, and I mean, I barely have the gas to get down there twice with a load. But yeah, I would like to go ahead and start moving out of here. Okay? All right, bye-bye.
Was that your son, Grant Hayes III?
Yes, sir.
And he indicated on that voicemail that he, Amanda, and Lily wanted to move in with you.
Yes, sir.
And at that time, did you own some rental properties around Kinston?
Yes, sir.
Okay. Why couldn't Grant move into any of those rental properties?
They were all occupied.
Okay. 1505 Holman Street, that's where you live? Is that
Yes,
right?
sir.
And 217 East Washington Street, that's where that Star Daycare is located?
Yes, sir.
And then you had some other rental properties on Cox Street, Independence Street, and East Washington Street?
Yes, 403 Cox Avenue and 307 Cox. My sister-in-laws live in those houses.
Okay, so those were occupied by two sisters?
Yes, sir.
And then were some of those lots vacant at the time?
There are 4 vacant lots. There's nothing on them.
And then was there another renter who was renting from you in another one of those houses?
Yes, at 211 East Washington Avenue, right beside the daycare.
And
The
who-
Rosses, Linda and I can't think of his name. Jonathan Ross. Linda and Jonathan Ross were living there at the time.
So back in July of 2011, there were no vacant rental properties that you owned?
No, sir. That's why, other than the 4 lots, that's why they were going to move in with us.
And to be clear, on that voicemail, Grant says that he, Amanda Hayes, and Lily are the
Yes.
ones that are going to move in.
That's what he said.
And does that message also say the boys are going to move there as well?
He just said he and Amanda and Lily.
After you received this voicemail, did you end up making a deposit for your son, Grant Hayes?
Yes, sir.
Eric, I approach the witness.
You may.
Ms. Hayes, do you recall how much that deposit was for?
It was $300 and some dollars, about $350.
I'll show you what's already been entered as State's
Yes.
Exhibit 581 and 582. Looking at this checking deposit that constitutes State's Exhibit 581, is that your handwriting on this deposit?
Yes, sir, it is.
Okay. And how much was that deposit for?
$350. It was a loan.
Now, on July 13th, that evening, you recall receiving more phone calls from your son, Grant Hayes?
No, sir.
Going back to those letters before you, Your Honor, at this time, I can't recall if I had moved to admit State's Exhibit 594, 595, and 596 in evidence at this time.
Oh, I understood.
Okay. Your Honor, may I publish those at this time?
You may.
Ms. Hayes, does that bring us up on the computer? Could you open State's Exhibit 594, the letter in front of you? Ms. Hayes, looking at State's Exhibit 594, and that's the letter from September of 2011, is that correct?
Yes, sir.
That list that is on the envelope that listed is from Amanda Hayes.
Yes, sir.
Your Honor, may I publish this at this time?
You may.
And it indicates that it's mailed from the Wake County Jail.
Yes, sir.
And moving on to the letter, first of all, is there a piece in that letter that's addressed to Chicken Man and Little Monkey?
Yes.
Are those, and does it say love, daddy, and mama at the bottom of that part?
Yes, sir.
Okay. Moving on to the letter component, this is dated September 24th of 2011.
Yes, sir.
And ma'am, could you read that for the jury?
Good morning. What a beautiful day. I just got the most amazing pictures of the most beautiful babies in the world. You have no idea how much I appreciate them. Thank you so much. I can't believe how big they all are getting. Oh my, I think this is a
Does that say goodness?
goodness. Oh my goodness. Lily is a little chunky monkey. She is so beautiful. I love the picture of her in just her diaper. She looks like her daddy. Can't wait to give them all big hugs and kisses. I love them all so much. Please give them all fishy kisses for me. Thank you also for the peaceful words. For the most part, I stay optimistic. I add to a very long list of blessings I'm grateful for every day. I have a beautiful view outside my window. I see many trees that will soon be changing colors. From the
Does it say from the front? I see-
front, I see the buildings and all the people. It reminds me of living in New York City. There is always a lot of activity going on down there on the weekends. I try to stay away from any drama. I have made friends with this young lady named Carla. We play chess a lot. She has been a real blessing to me. She will be leaving soon, and I will miss her. I guess I will have to teach someone else to play chess when she goes. I always read a lot, and I write a lot. I miss my family very much. Excuse me. Thank you both so much for caring for our children. Please tell my husband that I love him very much, and I think of him every day. Please send more pictures. They really made my day. Bless you both. Love, Amanda.
To be clear, you testified that this letter from Amanda says, please tell my husband that I love him very much.
Yes, sir, and I miss him.
If you could turn to State's Exhibit 594.
Okay.
That's one from January of 2012.
Okay. Oh, I'm sorry. I just read 594.
Okay, you're on coverage?
This is 595.
Thank you.
Okay.
I'm sorry. All right, Matt, State's Exhibit 595.
You may.
And then if you could read, are there two parts of that letter?
Yes, sir.
I guess, could you read the part that begins, hello there?
Hello there. I hope everyone is doing good. It was so nice to see you the other day. Too bad.
You said the monitor was messed up?
Okay, yeah, it's not working. Too bad the monitor was unused. Messed up. Too bad the monitor was messed up and I couldn't hear you. Wouldn't it be nice if our next visit is in person? I'm glad to hear everyone is healthy and doing well. I can't wait to see pictures of the kids at Christmas with all the stuff Santa brought. I'm so glad you are enjoying them all so much. I hope they are not too much work on you. Thank you for taking such good care of them. Here's a picture of a pantsuit that I like. My measurements are 36 chest, 27 waist, 36 hips. I know at the expenses.
I'm here to say Express.
Okay, I know at the Express and the Limited. I wear size 4 regular in pants and a size 8 in a jacket. I want
Does it say I want either white or off?
okay, I want either white or off-white, whichever you find. I want a baby pink shirt, something I can take the jacket off if I want. Just let me know if you have any more questions. I don't think there is a big hurry, but you never know. You never know. Thank you, and thank you for the other clothes too. Hopefully we will get to use them really soon. Take good care and talk to you soon. Love, Amanda.
Included in that letter, is there another piece of paper?
Yes, sir.
And on the margin of that piece of paper, does it say, to Grant, please read it to him?
To Grant, please read it to him.
And again, this letter is from what appears to be January of 2012.
Yes.
And could you read that letter from Amanda to Grant?
Hello, my baby. I love you so much, and I hope you are doing good. Excuse me. Please take good care of yourself. I miss everything about you and can't wait to give you a big hug and kiss. I had a dream we were all watching cartoons on our big bed on Saturday morning. I can't wait. I can't wait to see you and hear your voice. I promise I will make you fried chicken way more when we get home. I just want you to know how very much I love you. With all my heart, your wife.
And then if you could turn to State's Exhibit 596. Does that include you from February 7th of 2012?
Yes, sir.
And again, from Amanda Hayes to you.
Yes, sir.
And could you read that letter?
Hi. Hope everyone is doing good. I'm doing fine. I just wanted to send this note so you could read it to Grant. I want us to be able to pick times so we can both meditate together. I wish everybody I miss everybody very much. I would love to have more pictures when you get time. They all are growing so fast, and we are missing it. Thank you for taking such good care of them. I want to see Lily's hair and see her crawling. I know she is a mess. I know she is a mess. I'm so glad the boys love her so much. I can't wait to give them all a big hug. Hope you all have a great week, and I will be talking to you soon. Love you, Amanda.
Is there another part of that letter?
Yes, sir.
And how is that addressed?
To Grant.
Did you do that?
Yes, sir. Hello, my love. I very much want to meditate with you. I thought 6 p.m. and 11 p.m. would be good because we both go in at 5:45 p.m. and 10:45 p.m. I found this in a book. The best times to meditate are just before sunrise and at sunset. These are the times when nature slows her activity, birds are quiet, and animals do not stir. Because we are connected with nature, our minds and bodies are also still at those times. Yet, we can remain alert. Try to practice your meditation at the same time each day. I usually get up around 8 a.m., so there a time in the a.m. that is good for you. Get a pair of earplugs if it's too noisy. They really help. The 6 p.m. time is great for me. Let's a.m. time. And miss you.
And again, that was from Amanda to you, and you were to read that to Grant Hayes.
Yes, sir.
Nothing further, Your Honor.
Okay. Ms. Godwin, will you be examining?
I will, Your Honor.
Okay. You may, if you have questions, you may proceed.
Right, thank you, Your Honor. Ms. Hayes, I'm Rosemary Godwin. I'm going to ask you a few questions this afternoon. If you can't hear me, let me know. Sometimes
Yes, ma'am, I can
you
hear
can't
you.
me too well. In July 25th of 2011, when Grant and Amanda were arrested on these charges, Lily was left in your care. Isn't that true?
Yes, ma'am.
And at that time, Lily was only about 5 weeks old.
Yes, ma'am.
And over the past 20-plus months, you have assumed the maternal and mother role for Lily,
Yes, ma'am.
as well as for the 2 little boys.
Yes, ma'am.
And it would be fair to say that Lily's an adorable little girl, isn't she?
Yes, she is.
And you've bonded with her tremendously, I'm sure.
Yes, ma'am.
At this point, she would probably you feel as close to her as if she were your own daughter,
Yes, ma'am.
just like Grantina.
Yes, ma'am.
And when Amanda would contact you in fact, am I not right in that you and your husband had some engagement with the court system and got guardianship or custody, in fact, of Lily?
Yes, ma'am.
And it would be your intent your intent at this point to raise her as your own daughter.
Yes, ma'am.
And it was while you and your husband were watching these proceedings that you were prompted to contact the district attorney's office.
Oh, my husband, he called the district attorney's office.
And that was after you had seen and listened to Ms. Hayes testify.
Yes, ma'am.
Okay. Now, one thing, I've read these letters, and of course now the jury has seen them as well. And when Amanda would write you from the jail, or even contact you, y'all had some telephone conversations.
Yes,
from
ma'am.
the jail, and she always wanted to know how Lily was doing.
Yes, ma'am.
She was very concerned about her daughter and how she was bonding with you and trusting that you were able to fill her shoes when she couldn't be there.
She's asked about the boys also.
I know, and I was going to ask you about that next, but she was also very concerned about Grant and little Grant and Gentle.
Yes, ma'am.
And she was always wanting news about how they were doing and what was happening with them.
Yes, ma'am.
And in fact, I was begging you or asking you for, please send pictures, please send pictures.
Yes, ma'am, and I would send pictures.
And you could tell when she got those pictures that meant everything to her, didn't it?
Yes, ma'am.
I mean, she was very appreciative.
Yes, ma'am.
And throughout these conversations and writing these letters to you, she never put you in a position where you would have to you felt like you would have to take sides between standing by Grant or standing by her.
She usually just ask about the children.
And she would often, in these letters, tell you, if you talk to Grant, tell him I love him.
Yes.
And in these same letters, I was just noticing, please tell my husband I love him very much. I think of him every day. And the very next line is, please send more pictures.
Yes.
And she was very reassuring to you that she was maintaining a bonding to you and your family throughout this most difficult
Yes.
time. And that made it easier for you too, didn't it? To be able to communicate with her.
Yes.
And as a result of that, you were able to feel comfortable talking with her and getting her letters.
I was always glad to hear from her.
And you were always glad to send those photographs
Yes,
and
ma'am.
update her about the well-being of her child, Lily.
Yes, ma'am.
And in fact, because of this reassurance and this sense of a bonding that was maintaining in this difficult situation, you also began to feel comfortable allowing Shay to come to your home and visit with Lily.
Yes, and she would take Shay to her Lily to her house too.
She would have like a little visitation with her
Yes.
a couple of days here and there.
That's her sister.
And even when Karen Berry was here a few days ago, she visited with Lily as well.
I let her come and see the children.
And throughout all of this, you have kept a good communication with Amanda and with Shay and her family about Lily.
Yes.
And it was only after hearing, well, and Amanda never talked with you while she was writing you and calling you from the jail about any difficulties that she had had with Grant.
No, ma'am.
And it was only after hearing that, when Amanda testified in court that she had been fearful of Grant and that he had in fact threatened her with a letter while she was in jail, that it prompted you to contact the district attorney's office.
Her husband called.
And it would be fair to say that hearing Amanda talk about those things on the news, really on television, that it changed in some way the way you felt about the circumstances between Amanda and your son Grant.
Well, could you state that a different way?
I can. It would be fair to say that prior to yesterday and today, or prior to this week, let's say that, prior to this week, it's Friday, there had not been any tension or disagreement about anything between you and Amanda over your son Grant.
No, because she always said that she loved him and tell him that she missed him. She always spoke very well of Grant.
And you love your son very much, I'm sure.
I love my son very much, and I love Amanda very much.
And you have stood by Grant throughout these difficult times.
I sent him pictures, just like I do Amanda.
But you and your husband did not testify to anything at his trial, did you?
No, ma'am.
And you didn't come you didn't come and watch the trial.
No, ma'am.
When changing gears just a little bit, can you tell me what your telephone number is? Your cell number?
Yes, 25.
And I believe you provided the prosecution a copy of this voicemail that we heard today, where around 3:30, 3:45 on July 13th, you had received a call from Grant.
Yes, ma'am.
And in that call, he expressly says that Amanda, Lily, and I are going to be moving in with you.
Yes, ma'am.
He made no mention of the two boys coming with them, did he?
No, ma'am.
And it was your assumption, I would expect, based on that call, that they had worked out some arrangement where the boys would be staying with Laura while they came to live with you.
I guess.
Because Laura had a pretty nice apartment there in Kinston, didn't she?
Yes, ma'am.
And you had become aware that there were times when Laura would keep the boys for a little longer period of time than the normal weekends while Amanda was pregnant and having her new baby Lily.
Well, especially during the time when she was having the baby.
I think there was a couple of week time period, in fact, that Laura had them pretty much.
Yes, ma'am.
And when Grant was in Hawaii and Amanda was, 8 months pregnant here in Raleigh, she reached out to you and your husband for some help in making those exchanges with the boys to ensure that Laura got her time with the boys.
Yes, ma'am.
And y'all did, in fact, help work that out because Grant was unavailable due to his activities in Hawaii to be here to assist Amanda.
Yes, we picked the boys up for her brother.
Because Amanda was here with him alone while Grant was in Hawaii.
Yes, ma'am. We did transport the boys, I believe, one time.
Okay. Now, Grant's, getting back to this telephone call, you said your telephone number is 252-268-6639. And you said that he called that afternoon, but you don't recall any calls that evening.
No, I don't.
Would it surprise you that the telephone records indicate that Grant called you on July 13th at 11:29 p.m. and talked for approximately 10 minutes?
Objection to Grant.
Just a...
Would it surprise you that you received a telephone call from the same number you were called from earlier that day, where the call lasted about 10 minutes?
I don't remember it. I don't recall.
Do you recall that around 11:49 p.m. that you, or that your number, 252-268-6639, called back that same number that left the voicemail on your phone?
I don't recall.
Okay. You do recall that Grant needed money from you.
Yes.
I believe you said it was he needed money for gas and some other things.
That's what he said.
And you made arrangements for him to get that money.
Right, I made the deposit the next day.
And that was this $350.
Yes, ma'am.
He talked with you or left that voicemail reminding you that they were planning to come and stay at your home because they were getting evicted from their apartment in Raleigh.
And he needed a storage unit to put his things in.
Mm-hmm. And when Grant was with Laura, they had these two little boys, Little Grant and Gentle. And at some point in time, Laura came to live with you in Kinston,
Yes,
and then was in a rental, one of your rental properties.
yes,
And I believe at some time worked maybe at the daycare
she did.
because she was struggling to have a place to live for herself and these two little boys.
She did. She came to work at the daycare.
And during that time, Grant tended to travel because his work as a musician requires him to travel all around to other states and even other countries at times.
He was in the Virgin Islands when she came to live with me.
Okay. And he, at that time, did not seem to be able to provide a stable home environment for Laura, and that's why she had to come and stay with you until she could get on her feet.
I guess I didn't really get into all their affairs. I just know she came to live with me and the two little boys,
And
and I was happy to have her.
I'm sure. And it didn't appear at that time she really had anywhere else to go with those two little boys.
Okay, like I'm just saying, he's asked me could the boys, Laura and the boys, come and stay with me, and I told him yes.
Okay.
I didn't really interfere and get into their. I mean, they're grown-ups. They're my children, but they're grown-ups, and I try to respect that.
And then when Grant met Grant met Amanda, you were hopeful that that maybe Amanda might provide some stability for Grant. She seemed a little older and seemed to be a little more financially stable.
They seem settled.
But in about a year's time, Amanda had a baby, Lily, and Grant was telling you that they were losing the apartment and that they were going to have to come and live with you.
I don't know how much time went by, but she seemed good for Grant, and Grant seemed good for her. They were happy. Anytime we visit them, they were always happy. Now, I don't know how much time that's in between what you're saying, but
it would be fair to say by July of 2011, they had a new baby, and they were going to have to come and live with you because they were losing the apartment.
June of 2011, they had a new baby.
June of 2011,
Mm-hmm.
yes. Would it be fair to say, Ms. Hayes, that when Grant was a teenager and in his younger years, that there were times that he exhibited behaviors that caused you and his father to have some concerns about the stability of his emotions or mental state?
Grant was a sweet child. He was very docile, and he was a charming kid. So much so all the girls liked him in high school. A couple of teachers got jealous about it, but that's the kind of kid he was.
Do you recall a time in the home when there was an altercation between Grant and Grantina, and Grantina became so concerned that your husband took Grant and left for a little while so that everyone could calm down?
I think I do recall some of that.
And when he was involved with his first wife, that was Emily Lovers. They were, I believe, living in Greenville. And Miss Lovers was in school. Do you remember that, Emily?
Yeah, I remember when he was married to Emily.
And she was in school and was also working while she was in school. Do you remember that?
Yes, I remember her working and going to school. So.
And do you remember that it was during that time that Grant was finding it difficult to find work that suited him? And he even sought some psychiatric treatment during that time period for depression.
Now, I didn't live with them, so I don't know a lot about, their marriage or what he did then.
Are you aware that he did seek out psychiatric treatment and at one time was being medicated for depression and mood swings?
He was, I don't think I recall that.
Okay.
Because like I said, I try to stay out of their affairs.
Okay, just give me 1 minute, Ms. Hayes.
Sure.
Let me see if I have any other questions. Very much.
Anything else? All right, Ms. Hayes, thank you very much. You can stand down. You're excused. Thank you, ma'am. Thank you. Thank you. You can collect your evidence.
Okay. Excuse me, Your Honor, may I say one thing before I leave?
I don't know, because I don't know what you're going to say.
I want to go back to a
no.
question she asked me.
No, that's okay. I mean, I don't want you to say anything in the presence of the jury, okay?
Okay.
Just stand down, and if you need to tell somebody, you can tell them.
Okay. That's fine.
That's okay. Thank you
That's
very
fine.
much. Further evidence on behalf of the state.
Your Honor, this time I moved the admission of States Exhibit 588 through 593 that are pictures of Amanda's legs, and I don't seek to publish these at this time.
All right. Let them be received. Does that conclude the rebuttal evidence of the state?
Yes, Your Honor, that concludes our evidence. State reps.
Any serve rebuttal on behalf of the defendant?
No, Your Honor.
All right. All right, ladies and gentlemen, it appears that all the evidence is now completed in the trial of this case. It'll be that evidence that you review and evaluate and determine the truth of, and let your verdict speak the truth in this matter. The protocol of the court now requires that I conduct what we call a charge conference. Actually, I did that at some length on Wednesday after y'all left, and we stayed here another hour or so, and so we left at not a good time either. But in any event, I got a lot of that work done. I did it in anticipation of planning that if there was only a little bit of evidence left to be completed, we completed actually this morning, and we'd have closing arguments, and I would instruct you, and about this time, perhaps the jury would be getting the case. But of course, as you know from the testimony, there was an additional witness that no one knew about, and so that changed the schedule. We have now heard all the evidence. There will be no additional evidence, and we are at a point in which the lawyers will be entitled to make closing remarks to you, closing argument, and then I'll explain the law to you and submit the case to you. My instructions will probably take about 15 minutes. The lawyers' arguments will take longer. The rules of the court generally limit argument to both sides to no more than 2 hours. So it's possible you may hear 4 hours of argument. I don't know. They can take as long as they think is necessary and appropriate for you to understand the way they see, the lawyers see this evidence, and how they contend you should see it, and what they contend your verdict should be. The arguments of the attorneys are meant to help you, to direct your attention to things that you may have overlooked, to tie things together if they do tie together, to assist you in understanding their side of it and why their side of it is correct and the other side is correct. The other side's position is not correct. So I don't think you should be concerned about the time it takes. I think I think you need to be concerned about whether or not you know and hear and understand all the evidence and the positions of both sides before you retire to begin making what will obviously be a difficult decision. Please keep an open mind. Don't be careful not to follow my previous instructions. When you come in on Monday morning, we will have have arguments from the defendant's counsel, from the state's attorney, and I'll explain the case to you and submit the case to you. That's where we are in the procedure of things. I hope you have a good weekend, and I'll see everybody at 9:30 on Monday morning. Thank you very much. All right, the jury's absent. We will finish the charge conference that we began the other day. It is my intention to charge in the manner that I described to you in my previous written instructions, subject to any additional changes that you request that I make. The state has made a written request for 2 additional changes by way of the pattern jury instruction. The state's requested that I instruct on motive under 104.10, and I will give such an instruction. The state has requested that I instruct on admissions under 104.60, and I will give such an instruction. It basically says that if the defendant admitted a fact that's relating to a charge, that they should consider it under the circumstances in which it was made to determine whether or not it was truthful, and if so, to weigh it under those circumstances. The state has also requested that I include in the accessory after the fact to murder not only that the defendant willfully, knowingly, and intentionally assisted Grant Hayes to attempt to escape detection, arrest, and punishment by helping Grant Hayes dispose of dismembered parts of the body of Laura Ackerson, but also the state has asked me to include by helping Grant Hayes conceal evidence. What does that mean?
Your Honor, the situation could arise where the jury, in evaluating accessory after the fact, could say that buying acid to be poured on the victim's body obviously could constitute accessory after the fact, and if she wasn't the one who poured it, the law says, I believe, that she's still an accessory after the fact, and so Amanda Hayes' efforts at deception and attempts to conceal where evidence had been, I would argue the court is a little bit further than just disposing of dismembered parts. To me, when the jury reads helping Grant Hayes dispose of dismembered parts, that's going to speak to the jury that in the boat, actually putting the objects in the water, which we think there's clear evidence of anyway, but all the things that she did were to help conceal the evidence. And yes, they were also somewhat to dispose of the body parts, but that concealing, I would argue the court is violative of the law and makes her an accessory after the fact. And so I thought that by adding concealed evidence, it just encompassed all the behavior that we heard about in this trial.
Well, based upon the evidence presented today through the testimony of Ms. Bearcat, it would appear that there is some evidence now that the defendant acknowledged to her that she knew that Laura Ackerson was dead on the evening of July 13th of 2011. And based upon the fact that lots of items were removed from the apartment and placed in the dumpster, that an investigation may have shown that Laura Ackerson was murdered, and if she assisted in any way in concealing or disposing of that evidence, that would constitute accessory after the fact to murder, irrespective of what. If the jury found that to be true beyond a reasonable doubt, that standing alone would be sufficient to show accessory after the fact to a murder, if it was committed with the intent to help Grant Hayes escape detection, arrest, and punishment. So there is evidence, in addition to disposing of dismembered parts of the body, that could constitute accessory after the fact to murder. However, just saying conceal evidence or dispose of evidence is not, it's not clear what that means, and so I would believe that it would have to read, by helping Grant Hayes conceal evidence that Laura Ackerson had been murdered. Anything that would be evidence that Laura Ackerson had been murdered. Or by disposing of dismembered parts of the body of Laura Ackerson, or both, would be a more appropriate instruction based upon the evidence presented today. You can be heard? I think you probably want to object, but do you want to be heard further?
We'll object, but we don't respond.
Okay, all right. The objection's noted, but I'll use that language.
Yeah, I think it appears 4 times.
It does, and I'm going to have to go back and redo all this too. In view of the testimony today, I'm going to have to go back and redraw my reference to accident, and I'm going to have to use the specific language of the accident instruction. I had not made reference in the accident instruction to culpable negligence previously, but based upon today's testimony, I think since it's we don't just have what Grant Hayes told Amanda Hayes from her testimony. We also have what Amanda Hayes told Ms. Bearcat that she personally witnessed in her presence with regard to how this event occurred. And therefore, I believe that there is therefore some evidence that would require the court to define accident as under the 307.10 as follows: an accidental, a killing is accidental if it is unintentional, occurs during the course of lawful conduct, and does not involve culpable negligence. I had not used that term previously, but the pattern jury instruction uses it, and now I think, based upon the totality of evidence, that it would be appropriate to define it in that way. Therefore, I will redraw my instruction on accident. Any other, I do not, any other requests by the state?
No, sir.
All right. There is a written request by the defendant. Basically, that I instruct the jury that if they can't unanimously agree on first, then they'll consider second. If they can't agree on second, they'll go to accessory after the fact to first. If they can't agree on that, they'll go to accessory after the fact to second. If they can't agree on that, they'll go to not guilty. I guess that's what you're asking me to do. To instruct them that way.
Yes, Your Honor.
Yeah. And there's a case that give some guidance on that, I think. I actually think it was a case that I tried, and I refused to do that. Yeah. I'm not going to give that instruction in my instruction to the jury. But if the jury comes back and tells me they are hopelessly deadlocked on the homicide charge, then I'll allow you to renew your request to have me direct them to consider the accessory after the fact charge. If they come back and tell me that they're hopelessly deadlocked on the homicide charge, I will consider your request to tell them to proceed to the accessory after the fact charge. But I'm not going to tell them that until they tell me they can't arrive at a decision.
I understand exactly.
Okay. In fact, that's the context in which I believe that instruction should be considered, but not until. So your request that I include it in my original instruction is denied without prejudice of your right to ask me to direct them to consider it in that order in the event they find themselves hopelessly deadlocked as to one of the greater charges. Okay?
I understand completely. May I don't think we have renewed our motion to dismiss. We would do so at this point.
Right. I'm going to allow you to renew your motions.
And if I could ask, would you repeat the jury, pattern jury instruction number for accident that you intend to use?
307.10. And actually it's the one that I've been using all along. It's just I'd not made reference to culpable negligence because it's all part of the parens and the pattern jury instruction, and if the evidence doesn't support it, then you don't give that part of the instruction. But now I believe the evidence would require that I include that language in the instruction. And there are a couple of cases that are cited. I think I'll probably read those cases too, just to see if they're helpful. Anything else on behalf of the state with regard to the pattern charge? Anything else on behalf of the defendant with regard to the instructions that I'll give? Okay. Right, when we come in on Monday morning, we'll have closing arguments by the defendant's counsel. We'll have closing arguments by state's attorneys, and then I'll charge the jury. I do believe the rules, except in capital cases, the rules limit the arguments to 2 hours. I've never really limited lawyers' arguments in important cases, but if you can't say what you've got to say in 2 hours, you probably need to stop talking. So anyway, I'm not going to tell somebody to sit down, but I would assume that we'll get the arguments done in a period of 4 hours or less. Anyone think we'll need more time than that?
I promise you that I won't talk more than 2 hours.
Okay, great. That's great. I may remind you of that if you lose track of time. You all think you'll be more than 2 hours together? Okay, sounds good. We're getting near the end of this. Anything else? All right, good. Sheriff, take a recess until 9:30 Monday morning. Thank you.